this is an historic case, but also an historic injustice. The respondent, represented, as the court knows, by my learned friend, Mr. Price, together with his junior, Mr. Greaves-Smith, joins with us in submitting that DNA testing, which Mr. Malkinson had called for since his arrest, some 20 years ago almost, now supports his long-standing protestations of innocence. But also, as the court knows, those DNA tests, that fresh review, points to a credible suspect who could not be the appellant. And so therefore, he drew that anomaly to the attention of the jury. But it negatived. And I can say that with absolute force because the appellant was convicted. It negatived and demolished a reasonable prospect, a reasonable possibility of acquittal. Well, in fact, it does more than suggest. It shows incontrovertibly that the medical evidence read unchallenged to the jury was wrong. And it was upon that foundation that the learned judge postulated those questions. And those questions resounded, as they must have done in the jury, because we know, as your lordships will have read, that it was the second question, because there are 3 lots of questions sent by the jury, but it was the second question that the jury asked. They asked to be reminded of the scratch. No one can be in any doubt of the fundamental importance of that issue. If Miss C may have scratched the defendant, then Mr. Malkinson cannot be found guilty. Only if the jury is sure that Miss C did not scratch the attacker may they then exclude the evidence of her recollection and with it demolish the best, perhaps really, when one analyses this case, the only really strong defence point.
And on the face of it, not much investigation of that.
As far as anybody else was concerned, including the prosecution, they did not exist until Mr. Burley, who is present before your lordships, was allowed to look at a box in 2019 and found these photographs, which undoubtedly relate to this case, but which hitherto had absolutely no provenance at all. Neither the statement of the photographer who took them, nor their existence was ever committed to paper. Independence raises a very interesting question in this case. And I'm not asking the court to sit as a court or a tribunal of inquiry. I'm asking the court to look at, as it must, on what the defence could have done with the following information, which was not disclosed, and which might indeed have profoundly undermined the suggestion that they were independent at all. And when I use the term they, there is no doubt that they were welded together. They were partners. But I refer, of course, to Mr. Seward's involvement with the authorities during the time, in fact, the entire currency of his status as a potential witness and actual witness in this case. These are not fanciful, armchair general observations by me, I respectfully submit. It is recognised that the force of previous convictions in undermining credibility and confrontation is a fundamental right to be able to cross-examine witnesses in the most powerful way possible. So on the very day that he comes forward, independently, he was arrested. And it is an inescapable conclusion that his involvement in this case comes as a result of his commission of a criminal offence, because he admits that he was driving immediately before he saw the mobile police station. So the essential fallacy of the prosecution's case, that these previous convictions are irrelevant and that they would have had no impact on the course of this trial in accordance with the test set out in McInnes, is fallacious. Purportedly honest, they were not. Purportedly independent, they were not. Without any interest to serve other than being civic-minded witnesses coming forward to do their public duty. Whilst, as I postulated, fresh scientific evidence can quash a conviction, the vital question of the real possibility of an acquittal in 2004 is important for the proper vindication and the wider interests of justice in Mr. Malkinson's case. Deal with it very briefly, my lords. The Article 6 rights of the ability to challenge and confront denied at trial, and which blighted an appeal, particularly given the fact, although the appeal was taken principally on other matters to do with contamination, which I need not trouble the court with, but there were two grounds of appeal that went to the binary decision, which I've respectfully submitted was a fundamental obstacle to conviction, a winning point for the defence. Although this court's principal focus is to determine whether a conviction is unsafe, we respectfully submit that these convictions were unsafe at the time without the need for subsequent scientific evidence, that the cumulative effect of the material non-disclosure as to the error of the doctor, which negatived a winning defence point, and the material non-disclosure that would have wholly undermined confidence and credibility in the independence and the reliability of the only supporting evidence from those two witnesses, is therefore, we respectfully submit, fanciful for the respondent to suggest that they're irrelevant, that they have no impact, and that the verdicts would otherwise have remained the same. Those are my submissions on behalf of the appellant. I'm very grateful to my learned friend for stating that Ground One provides an unreserved vindication of Mr. Malkinson. I'm very grateful for that, because I respectfully submit upon that one can properly submit to the court without exaggeration that although the word innocent has not been used, because my learned friend confines himself to the legal test under the Criminal Appeal Act, the essence of that submission is the same. But there are core process values, so far as the administration of justice, that have very, very sadly and lamentably fallen far short of the mark in his case. And that vindication that he may have been acquitted in 2004 is vitally important for him. These very serious departures we submit from the Criminal Procedure and Investigations Act deprived and denied Mr. Malkinson of the ammunition that he needed to challenge the prosecution case. It went centrally to the issue of identification. Ground Two goes to identification. My learned friend submits that it does not. It goes directly to the issue of identification and the binary choice that the jury had. Again, I emphasize, it is not for this court, and this court, no doubt, could not, in any event, pronounce on whether that non-disclosure was malignant or inadvertent. But non-disclosure it was, and it deprived the appellant of the vital material required to explore the merits of the prosecution case and to confront it. And it's for those reasons we respectfully submit that the court ought to grant leave in this case for those other grounds.